Further compounding the stupidity that is British Columbia's distracted driving laws, an acquittal that made perfect sense was overturned in BC Supreme Court this week. This case involved an Uber Eats driver who used his phone while he was driving. It was mounted. He tapped it because he had a very short window to accept an order or it would be offered to somebody else. So he taps his phone to accept the order. A police officer sees this, pulls him over, and issues a ticket. He challenged the ticket in BC Provincial Court and Traffic Court and won because the judicial justice said what makes logical sense. If you're allowed one tap to end or accept a call, then you should also be allowed one tap for the purposes of using your Uber Eats app and accepting a job. I mean, after all, we create legislation in British Columbia to work around the gig economy. People gotta work. It's no more distracting to tap for Uber Eats than it is to tap to say, I don't want to talk to you, Fred. You pissed me off. That makes perfect sense, right? BC Supreme Court overturned this. Why? Because even though it's unfair and stupid and illogical, the letter of the law must prevail. And the letter of the law says that you are only allowed one touch for those three specific purposes, ending, initiating, or accepting a call. Meaning you cannot touch your phone for any other purpose. No shuffling, no changing your GPS directions, no tapping your phone to accept a gig economy job. It's absolutely dumb. And the judge even commented that, yeah, this is likely unfair. But as the court is concerned, they don't deal with the unfairness of the law. All they deal with is what the law says. They interpret and they apply the law. And this is just yet another example in a long list of terrible examples of this bad law that needs to be amended. So hopefully 2025, we will see a law 15 years after it came into force and effect amended to reflect daily life in British Columbia and our interaction with our devices. But I'm not holding my breath.